in the year 2005, there was a manual on human rights and the environment which was adopted by the Council of the Europe. In this particular manual also, there is one particular point where it has mentioned a kind of obligation has been imposed upon the state, that the state will have to tackle those critical situations which are very much adverse to the public health. The state will have to tackle those situations which is very much where there is a need of appropriate legislation, but in fact where those legislations can tackle the problem. So you see in this particular manual what has been mentioned, that is the importance of appropriate legislations to tackle the current problems, the contemporary problems, and it has also inferred about the other perspectives of assessing and evaluating environmental risk, because here in this particular convention which has also been mentioned, that is the risk factor, and it is very difficult to quantify the risk. What are the environmental risks? Because you see, when we refer with other conventions, we find out there are a number of environmental risks altogether. So there in this particular convention, it has mentioned that the state has a specific duty as a matter of priority to assess the environmental risk and to act accordingly on these bases. So these are the two basic principles which has been referred before the European Convention on the Human Rights in the year 1950 also. Now another issues which we generally come into conclusion after reading all these conventions, that is, what is the challenge before this international environmental law. Now when you are talking about the challenge before international environmental law, the first issue will obviously comes, that is the air and water pollution, which is the most common principle which we are able to find out in developing countries also. Second one is the deforestations, and third one is the threat to wildlife also. Now these three basic principles directly and indirectly has put an adverse impact upon the health, upon the quality life of the living standards time and again also. But there are other factors which are also very much directly and indirectly connected with these issues, like the problem of poverty, like the problem of overpopulation, or like the problem of rapid depletion of the natural resources. Now these problems may not be the direct result altogether of the environmental degradation, but somehow they are connected with the environmental degradation, somehow they are becoming a challenge before the state to encourage environmental protections. Now when these things has come into picture, obviously we have to search for the solution. So where is the solution lies basically? Solution lies that we need a silent regime also, where we can tackle silent legal regime, where we can tackle these issues and where we can identify and recognize social right, economic right, political rights, and the cultural rights. Because these rights will play a very crucial role whenever we face any difficulty while understanding the relationship between environmental law and between the human rights. So this is how these are the possible challenges which have come across before the international environmental law also. Now when we discuss about this international environmental law, obviously first thing we have to realize that what is the effect of climate change upon the human rights. The moment we are talking about the effect of climate change on the human rights, obviously the first one is that is the negative impact on the ecosystems through environmental pollution and the deforestations. But it is not the only thing, there are other factors which are also involved, because for examples there can be certain adverse ramifications of the human rights through life, in the case of water, in the case of health, and in the overall in the case of economic development of a person and of the community also. So you see how the climate change has adversely effect altogether on the human rights. So you mean to say one thing, we have understood one point clear here, that whenever we study the negative impact of these particular issues, this is another issues which has come across, that we need a climate justice, just like which we have discussed about social right, economic right, political right also. This is another issue which have come across, that climate justice through the prevention of illegal exploitation of natural resources and pollution with inter-state cooperation can play a very crucial role. So you mean to say we understand this point, that in this this environmental climate justice plays a very crucial role altogether in dealing with these issues altogether. Now the next topic which are we going to discuss, that is right to clean and healthy environment under the constitution of different countries. Now, when you are talking about right to clean and healthy environment in the constitution of different countries, first thing we will discuss about that it is the Portugal which is the first state altogether which has identified and legally recognized right to have a clean and free environment. In fact, under the article 35 of the Korean Act also, they have also identified the right to healthy and pleasant environment which is available for all the citizens. But when we see the Spanish constitution, they have a very peculiar features. They does not only talks about right to enjoy environment, which is very much necessary for the development, but apart from the conservation and the preservation of the environment, they also talks about the obligation upon the public authorities to ensure reasonable utility of the resources. When we look upon the Brazilian constitutions, there they are talking about the right to have an ecologically balanced environment. They also talks about that not only the government, but in fact it is the community also have a duty to protect the environments, not for the present and as well as for the future generations. So this Brazilian constitution, what we see, it basically talks about environmental sustainability. It also talks about the balance of ecology also. When we refer about social federation, the constitution of social federations, they have talking about right to have a favorable environment also. They are also talking about right to compensation for those persons who are affected with environmental degradation. Now this is something peculiar, this is something different from other constitutional provisions as given in the world also, because there you are talking about compensation as an alternative remedy. So you see, when you refer about this constitution of Russian federalism, it has been inspired, it has been taken into consideration seriously by many developing countries, and in fact in our country also we follow this principle in the form of precautionary principles, in the form of polluters pay principle also, to a certain extent, though it is difficult to identify, though it is difficult to quantify the same also. Next one is, that is, we are talking about the South African constitution. South African constitution talking about right to have a health, right to have a quality environment also. There also talks about that this environmental sustainability is very much important to prevent the environmental degradations, and they are saying that the socio-economic development will not be possible until unless we will not have a preservation of environment. So you see the beauty, you see the importance which has been mentioned in this particular constitution has given in this manner.